security through the installation of firewalls or intrusion detection systems to monitor your network traffic for suspicious activities or policy violations. So it might be very important for you to retain the services of a cybersecurity expert or an IT professional to assist with the configuration of these systems. Then there is also the option of implementing endpoint security for your endpoints like laptops, desktops, and mobile devices through the installation of antiviruses and anti-malware software. So these are some of the technical measures that you can implement as a business to enhance data security. Now, speaking of organizational measures, it is very important as an organization to have a very strong security policy. It speaks to data governance, and as a data protection compliance organization, we assist clients in preparing bespoke security policies. It is also important to conduct regular risk assessments and penetration testing, where you retain the services of a certified ethical hacker to simulate a cyber attack to determine whether you have vulnerabilities in your system. Then it is equally important to regularly train employees on issues relating to security. Also, when the processing of personal data will result in a high risk to the rights of the data subjects, Section 28 of the Data Protection Act mandates data controllers and processors to conduct a data protection impact assessment. Now, the essence of the assessment is to mitigate the risk or even eradicate the risk, but at the least ensure that you put in place measures to mitigate or cushion the effect of the risk. Then, very importantly, you must have a disaster recovery plan or an incident plan for you to bounce back after suffering an unplanned incident. I know the focus of the topic is to prevent data breaches and enhance data security, but we need to accept the reality that these breaches may still occur as these cyber criminals, these Yahoo boys, are becoming more adept at carrying out their nefarious activities. In fact, the Nigerian Communications Commission implemented a guideline in 2023 named the Guideline on Disaster Recovery Plan, mandating service providers and network facility operators to have a disaster recovery plan for them to bounce back after suffering an unplanned incident. An extension of this measure is the data breach compliance obligation or notification obligation. So the Data Protection Act, I think Section 40, mandates that where a breach will result in risk to the rights and freedom of individuals, you must notify the Nigeria Data Protection Commission within 72 hours of the occurrence of the breach. Then when the breach is likely going to result in a high risk to the rights of the data subject, you must immediately notify the data subject and also advise the data subject of the mitigative measures they can put in place to reduce the impact of the breach. With the amendment of the Cyber Security Act, the Cyber Crimes Act rather, there is now an obligation on service providers, I think as contained in Section 21 of that law, to immediately notify the National Computer Emergency Response Team Coordination Center in the Office of the National Security Advisor of any breach or attack. A failure to do this within 72 hours will result in the payment of fine of up to 2 million payable to the National Cybersecurity Fund. So these are some of the organizational measures that we can put in place to prevent data breaches. And that brings me to the end of the CIA triad principle. Now, another principle relevant to data security is the data minimization principle. The principle provides that data collected or the collection of data must be limited to the minimum necessary to achieve the purpose of collection. The two components of this principle are relevance and necessity. That is, the information you're collecting from the data subject must be directly relevant and necessary to accomplish the specified purpose of collection. For example, let us say as an organization, we want to start sending virtual newsletters to everybody on this webinar. The information we would need from everybody on this webinar will be the first names of everybody, the email addresses, and possibly the subscription preferences of everyone. Excessive information will include phone numbers, home addresses, as those information are not necessary for the processing. Now, how is this relevant to data security? By collecting and maintaining only the minimum amount of information necessary, the volume of sensitive information that may be exposed or compromised in the event of a breach is minimized. So fewer data means fewer targets for malicious actors. Another relevant principle, please, have I spent up to 30 minutes?
No, not yet.
Okay. So another relevant principle is the storage limitation principle, which provides that data must not be retained for longer than necessary to achieve the purpose of collection. That is, once the intended purpose of the data has been achieved, the data should be discarded. And the essence of this, just like the data minimization principle, is that it reduces the volume of information that may be compromised in the event of a breach. However, it is very important to balance this principle with other legislative and regulatory requirements. For instance, if there is a legal stipulation mandating the retention of data for a designated duration, then that provision has to be complied with. For example, I know Section 38 of the Cyber Crimes Act mandates service providers to keep subscribers' information for up to 2 years. The Companies and Allied Matters Act also mandates that documents archived in soft copies must be kept for 6 years. So, but in any event, as a data controller, you need to establish retention schedules specifying the retention period for the data that you keep. Another principle is the data accuracy principle, which provides that the data you're collecting must be accurate, complete, not misleading, and kept up to date. Now, accurate data allows for proper configuration and implementation of security measures. So, for instance, if access controls, which I spoke about earlier, is based on accurate data, then the likelihood of unauthorized access will be minimized. For instance, let us say as an organization, we process information or financial information of some other businesses, and only the members of our finance team has access to that information. It will be very important for us as an organization to maintain an accurate employee database, separating the members of the finance team from the members of the HR team, for instance. So if there is an error or there is an inaccuracy in our database, maybe somebody from HR team is put in the database for the finance team, the implication will be that that person in the HR team, right, will have access to information he or she is not supposed to have access to. So it is very, very important for us to pay attention to the principle of data accuracy. Then there is also the purpose limitation principle, which provides that the data you're collecting must be for a specified, explicit, and legitimate purpose. And the data must not be further processed in a manner that is incompatible with the original purpose. So the proposed use of the data must be clearly defined and explained to the data subjects. So how is this relevant to data security or avoiding breaches? We need to understand that the misuse of personal data is a form of data breach. So as a data controller, you must ensure that you're not processing the personal data of the data subjects beyond the scope originally intended at the point of collection. For instance, let us say I engaged the services of a professional to set up a multi-factor authentication for me on my phone. And that process requires me giving in my phone number. Now, after setting up the multi-factor authentication for me, he now starts sending me promotional materials for some other businesses he does, right? That is contrary to the purpose limitation principle, because that's not the reason why I gave him the data in the first place. The sole reason why the data was given to him was for the implementation of a multi-factor authentication for my device. So I think I will stop here for now. Maybe when Caleb shares his thoughts, I will discuss the outstanding principles. Thank you.
Okay, thank you very much, Mr. Olatunji. That was a very insightful session. You spoke about the CIA triad principles, that's confidentiality, integrity, availability, as well as the purpose limitation principles, and about how malicious attackers can enter into the system of any organization and cause malicious harm or breaches to that organization's policies, procedures, etc. Thank you very much for that succinct but yet elaborate discussion on data security. So now I'll move to you, Mr. Agio, where you're going to talk about legal compliance. How do organizations, take this a step forward to ensure that they are compliant with the various laws? For instance, Mr. Olatunji has spoken about the NDPA, he has spoken about the Cybercrimes Act and a number of other acts. Now, how do organizations take this forward? Thank you.
Okay, thank you very much, Ayomide. Thank you, Tunji, for that introductory, very well explained detail on providing integrity and security to data. Clearly, what the Commission seeks to achieve is to see that if you do not have the facilities to protect data and manage data, then you shouldn't be in the position of collecting data. As a matter of fact, part of what is required for any organization that will be processing, collecting that amount of data is to ensure that they have the right system, the right apparatus to protect the integrity and the security of those data. And this leads me to answering the question that Ayo asked on compliance. And the laws or the legal regime for regulatory works or requirements for data protection has just been evolving at a very commendable rate. And data protection regulation of 2019 provides very clear outline, and of course the recently passed Nigerian Data Protection Act also makes clear provisions, which if you are approaching the regime, it might look a bit confusing, but good thing is that you have to make recourse to the transitional provisions of the Act to be able to appreciate all of the existing laws and take a path in terms of keeping with compliance, as far as compliance matters are concerned, is concerned. So for businesses, they are required to ensure that they have data protection policies and that those policies are published at even the point of collection. All right. So it's very important that every organization that will be collecting data have a data privacy protection policy that outlines how they intend to respect the rights of data subjects and how they intend to protect those rights. Section 40 of the Data Protection Act provides for registration of data controllers and data processors of major importance. And that's where the regulation really begins, in my view. The data protection, there's requirement to be registered with the commission, and the commission has released a guidance note for registration of data controllers and data processors. And I think right now it has extended the registration period to the 31st of October. That's this month. And it more or less divided or classified the kinds of organizations that should be registered and under the commission. And the thresholds are broad and distinct, but basically different, classified into three major data controllers and data processors that of major importance, processing ultra high level data, then extra high level data, and ordinary high level data. So the minimum is if you process personal data of up to 200 people within a space of 6 months, you are required to register with depending on the sense operating in, it will differ under. And if you are in that interacting with data subjects, or you are in any of the sectors outlined in the notice for registration of data controllers, healthcare, communication, education, insurance, you have to register with the NDPC. Right. So, and once that is set, then the next requirement or regulatory requirement for data controllers, data processors, organizations that process that amount of data is they're required to appoint in their offices Section 33. Section 32 of the Act actually requires them to appoint a designate data protection officer. The data protection officer is the one who is more or less responsible for monitoring and working with the management and with the company on an internal basis to ensure that they keep in line with all the data protection laws and regulations. So it's more or less the internal person. The Act provides that it may be an employee of the company, or it may be someone who is providing that service on a contract basis. In fact, the regulation allows for the DPCOs, which we'll definitely find out shortly about, to designate one of their own or one of their members to act as a data protection officer in any of the registered data controller or data processors office. required to also have a data protection organization whose work, and that's in line with Section 33, and the work of that person is to act as more or less a representative of the commission to ensure that there is compliance. And then the data protection compliance organizations that's DPCOs, are responsible for carrying out the requisite audits and ensuring that, okay. Sorry, can everybody hear me? Okay, and to ensure that they keep in line with the provisions on the data requirements and compliance matters. The law Crest, fortunately, is a registered data DCPO, and the major bulk of the work really is to ensure that the data controllers and data processors that are registered carry out their audits, and then assist them with whatever privacy documents they need to prepare, and just to be sure that they are, compliant with the provisions of the law. All right, and this is also essentially because the Act also requires such registered data controllers or data processors to file in on a yearly basis the audit of their data activities. These audits would usually outline the kinds of data they process, how they are being processed, whether they have a data protection officer that guides their conduct, and whether there have been risks, breaches, and those sort of things, just so that the commission can have an idea of what extent they have been compliant with the law. Section 28 of the Data Protection Act also talks about the data impact assessment, which is more or less a requirement where the organization is thinking of processing data in a way that exposes or has or shows a risk that there will be data breaches. For example, if they are trying to create a new system that requires maybe transitioning the interaction of people's data on a electronic platform or some sort, where they would more or less process data in a different manner than the manner in which it was initially collected or said to be processed, then in that case, they are required to conduct an data impact assessment, which usually would come with the assistance of the DPO and as well the DCPO, and should be filed. The Act actually requires that before, provided that those risks exist, you must inform the commission and file that impact assessment with the commission. The idea behind that is to ensure that you are doing that in consultation with the commission to ensure that the data processing is the data processing will not infringe on those rights, and that as much as possible, there's minimal, there are measures that are put in place to ensure that that processing activity do not result in the breach of the rights of the data subject. Just a minute, over to you, Ayomide. To just a minute.
All right. Thank you very much, Mr. Agio, for the explanation that you've given to us in relation to DPCOs, the requirement for compliance, and the fact that every organization, particularly data controllers and data processors of major importance, must have a designated person who is a data protection officer, who is someone that actually has the expertise, not just someone that takes that role, a name only or entitled, but does not have the critical functions to carry out, critical capacity rather, to carry out that particular function in that role. And another point to note also is that the commission has consistently, insisted that this DPO, must be someone that is resident in Nigeria. Even if you are a company that is not physically situated in Nigeria, you are a multinational and you have your base of operation is outside the shores of this country, it's important that as long as you process data that it comes within the scope of the NDPA, that you have a DPO, that's a data protection officer, who is resident in Nigeria. So quickly, thank you very much. Now we're going to just delve into, cross-border data transfer, because we realized a lot of our clients and a lot of organizations actually routinely, from time to time, and in special circumstances, they actually transfer data out of the borders of Nigeria for one purpose or the other, maybe payroll function, HR function, their archive function, etc. So can you just take us through maybe the procedures and the importance of going through those procedures in transferring data out of the borders of Nigeria? Thank you.
Okay, so thank you very much, Ayomide. Sorry, I heard that at some point the network must have been muffled. Okay, so when it comes to data, cross-border data transfer, the Act takes two major approaches to it, which I will call the adequacy protection approach and then the derogation approach. Now, I must mention that our interpretation of the Act and, of course, the existing legislations on the matter has been that the intention of the Act is that you consider the adequacy of protection approach before, and where there is no headway in that approach, then you can consider any of the exceptions under the Act, which I just referred to as the derogation approach. So what is essentially the data protection adequacy approach? So you are transferring data. I'm going to just explain it as simple as I can. You intend to transfer data outside the country. We see that in some cases where, for example, the company, maybe for efficiency, decides to transfer part of its operational functions, whether finance, whether HR, whether some other function outside the country to be managed by some other institution, and that would require moving personal data of persons here outside the country. Or you might even find it in where, for example, a local business has been acquired by foreign jurisdiction, and they needed to consolidate that operation, and they need to move that that function, which of course involve moving personal data outside. The requirement of the law is that there has to be, the idea about the adequacy protection approach is simply that the Commission needs to be certain that the foreign jurisdiction where you are transferring those data to have the adequate protection, affords the data subjects the adequate protection of their data. And so it would be deemed not to have the adequate level of protection where that jurisdiction falls short of the kind of protection that those data subjects enjoy here in Nigeria. So you can't just move us from forgive my terminologies, from fry pan to fire. That's the idea behind it. And so Section 41 of the Data Protection Act explains it, that where the recipient of personal data is subject to a law, binding corporate rules, contractual clauses, code of conduct, or certification mechanism that affords an adequate level of protection with respect to the personal data, then of course, that is the condition in which you can transfer data. So they must be subject to laws, binding corporate rules, contractual clauses, and code of conduct that allows adequate level of protection in the foreign jurisdiction where those that data will be transferred. And that decision or determination on whether or not there's adequate level of protection in the foreign jurisdiction is not one that is reserved for the data controller or data processor that is doing that transfer. It's something that is reserved for a joint consortium with the Commission. And so the typical approach would be to apply to the commission detailing, putting down a detailed provisions on how that country or the foreign jurisdiction or the data recipient has all the tools or all the factors that gives adequate protection. So in explaining adequacy protection, Section 42 of the Act more or less gives a better expansion that in determining adequacy, you consider the availability of data subject rights, the ability of data subject to enforce their rights through administrative or judicial processes in the foreign country. So you know that, of course, there's no adequate protection where the jurisdiction where that data is being moved to would not allow people to enforce their data privacy laws or acts. So I don't know if perhaps so that's essentially just one of the major factors that will be considered in determining the level of adequate protection. There has to be some sort of existence of an appropriate instrument between the commission and a competent authority in the recipient jurisdiction. So it's one of those things they'll need to look into, whether for some reason there's a bilateral understanding between Nigeria and that recipient country on the issue of data protection, or whether there is part of what we'll look at is just the same way we have the questions that will be asked is if in that foreign jurisdiction there is a regulatory institution that looks or regulate the issue or enforces the issue of data protection and breaches, and that the data subject will be afforded the same kind of protection he would have gotten if the data remained here in Nigeria. The legal framework for data protection in that place, as I mentioned earlier, the existence of a functioning independent competent data protection and or supervisory authority, very, very important. And of course, if there are international commitment or bilateral arrangements on data protection would also be very helpful. Recall that just before the coming of the passage of the NDP, Nigerian Data Protection Act, the procedure required an application to NIDA, and NIDA was working at the time with the Office of the Attorney General. But the provisions of the Act seem to have, discharged the Attorney General of that overseeing function. And you could also recall that part of what the Commission did at the time to assist in resolving the issue of adequacy protection was the creation of the white list, which was more or less a list of countries which, in the opinion of the Commission, had some level of, some adequate level of protection. But you will recall that in the case of Incorporated Trustee, the Ikagal Innovation Institute case versus NIDA, the Federal High Court held against NIDA that while the white list, which includes countries without adequate, that the white list had countries that did not have adequate protection. Various people have argued that that judgment, in effect, really nullified the list. Some have argued that it more or less nullified portions of the list that the judgment referred to, because in that case, it was alleged that that NIDA had put in that white list some countries that did not have adequate protection. As such, the list could not be relied upon. So if you are taking a conservative view, I would simply, my view in dealing with that issue would simply be to do one's own research and, putting all of those considerations in showing the Commission that there is adequacy, there's an adequate level of protection and data protection in that jurisdiction. Now, this leads me to the second arm of it. Section 43 says that in the absence of the adequacy protection under section 42, that is to say, where for some reason the commission does not determine that that country or that jurisdiction has the level of adequate protection. Now, there's also the position that you may arrive at that junction of the absence of adequacy protection in the foreign jurisdiction when the commission does not respond to you within a reasonable time. The Act now provides for another leg, which I termed the regression approach, or will I say exceptions to the data, to the adequacy approach on the subject. And the list of exceptions to when you can transfer data out of Nigeria in the absence of an adequacy data protection adequacy test of approval is where, for one, the data subject provided and has not withdrawn his consent to such transfer. I believe this is one of the easiest way for companies or businesses to deal with these kind of issues. If you have applied to the commission and you are not able to determine adequate level of protection in the foreign jurisdiction, then you have to get a sustained or informed consent of the data subjects, and letting them know this is what you want to do, and these are likely risks with what you want to do. And then, of course, once you get those approvals, those consents, then you can proceed with that. Another exceptions listed in the Act includes where the transfer is necessary for the performance of a contract to which the data subject is a party, or in order to take steps at the request of the data subject prior to entering that contract. So this is another exception to that. Another exception is where the transfer is for the sole benefit of the data subject, and it's not reasonably practicable to obtain the consent of the data subject. And even if it was reasonably practicable to obtain that consent, the data subject would likely give his consent to it. And of course, another exception is in the interest of public policy, or where the transfer of the data is in the establishment, exercise, or defense of legal claims. So that essentially covers the framework, or the compliance framework, for transfer of data outside jurisdiction. I'm sure we've seen situations where it's a massive parent company that has subsidiaries here in Nigeria, and the question would be, hey, if a subsidiary in Nigeria, local company, wants to send data to the group, would they need to comply with this? Yes. What they need to ensure is the same adequate level of protection when that data will be moved to that to the recipient group. And of course, they may need to outline if it's some sort of corporate rules or some sort of agreement that allows them to do that. And then, of course, the mechanism for protection that is afforded under that framework would need to be sent to the commission for approval. As it says, the commission may approve binding rules, code of conduct, certification mechanisms, or similar instrument for data transfer proposed to it, where the commission is satisfied that the instrument meets appropriate level of protection. So that can also happen. I don't know. I mean, I guess I hope I was able to summarize that very quickly. Thank you.
Yeah, thank you, Mr. Agio, for taking us through the procedure for cross-border transfer, because it be a very tricky and stressful procedure, because a lot of clients or a lot of organizations prefer to go the short way around and just go to the derogation, give whoever the data subject a consent form, rather than trying to see, okay, the recipient country, do they have adequate data protection laws? Do they have an independent body that enforces the data protection laws? Do they have a mechanism for redress? They instead prefer to just go the short way around and get a redress a consent form. But in several jurisdictions, including the EU and the UK, they've emphasized that it is better, or first of all, you need to check whether there's an adequate mechanism for the protection of the rights of this data subject before going on to see how you can derogate from this right and go one way or the other to make sure that that particular data or information is being transferred. Thank you very much, Mr. Agio. So now I'll just go back to Mr. Olatunji to round up briefly, basically on the storage accuracy and also there have been a number of questions in the Q&A box asking for more explanation on the CIA, that's the confidentiality, integrity, and availability triad principle, so that we can just round up and head into Q&A.
Okay, thank you, Ayomide. So I think I had discussed 5 of the principles earlier. So we also have the lawfulness, fairness, and transparency principle. So it's a 3-pillar principle. Lawfulness means that the processing of a personal data has to be rooted in a legal ground. Sorry, Ayomide, please, there is an interference. It has to be rooted in a legal ground, and that there must be a legal basis for the processing. So while having a legal basis alone does not directly prevent data breaches, it establishes a framework for organizations to handle data responsibly, which can indirectly mitigate data breaches. So some of the legal bases are reflected in Section 25 of the Data Protection Act. There are 6 of them, and I think Caleb touched on most of them while he was discussing the cross-border transfer of data. So you have consent, you have performance of a contract, you have compliance with legal obligation, you have protection of vital interest. Vital interest would mean something that relates to life and death. You have public interest and the legitimate interest of the data controller. Now, fairness and transparency pillars relate more to letting the data subjects know how their data are being processed. They need to know everything that is happening with how their data are being handled. So when data subjects are aware of how their data are being handled, they are more likely to comply with security measures and report suspicious activities to prevent data breaches. So for transparency, data controllers need to pay attention to these, and they can achieve this by putting out a privacy notice or a privacy policy in compliance with Section 27 of the Data Protection Act. A privacy notice would typically tell you what the legal basis is for processing your personal data. Is it consent? Is it compliance with a legal obligation? Is it contract? Is it the protection of vital interest? Is it public interest? Or is it for the legitimate interest of the data controller? Then you should have things like the retention period. How long will the data controller retain your data? Then the recipients of the data, let me know the people who are going to have access to my information, right? So a data controller holds that obligation to a data subject. And what are my rights as a data subject? This has to be contained in the privacy policy. For instance, I have a right not to be subject to automated decision making, right? So what's your policy regarding things like automated decision policy? Will my data be transferred across the border? Let me know through your privacy policy. So all of these things have to be embedded in the privacy policy. Then I also need to know your policies on cookies and other tracking technologies, right? So the way cookies work is that when you visit a website, for instance, the website saves the small texts on your browser, which makes the website remember your device whenever you revisit that website. For people who watch movies online, for instance, you will notice that sometimes when you're watching a movie on a website and leave the website, by the time you go back to the website will take you to where you actually were as at the time you were watching the movie, right? So that's a function of cookies. But the downside is that some dark webs, right, install tracking technologies on some of these cookies. So you have to be very, very careful about the kind of websites you visit. You have to ensure that when you're visiting a website, the hypertext transfer protocol secure. HTTPS is reflected in the website. So those are some of the security tips that you need to pay attention to. But the data controller needs to put all of this out, right, in its privacy policy. Now, the last principle is the accountability principle. Now, as a data controller, you owe a duty of care to your data subjects, and you must be able to demonstrate accountability in relation to all of the principles I have spoken about, including the CIA triad principle. And the way we can do this is by some of the things Caleb has already talked about, right? You can display accountability by ensuring that you retain the services of a data protection officer. You can even take it a step further by having a data protection compliance organization to monitor, audit, and report compliance to the Nigeria Data Protection Commission. You can also ensure that you conduct your data protection impact assessment when necessary, and also file your periodic reports, as Caleb talked about earlier. So those are the principles of data protection. So I think we can go to the Q&A session so that I can discuss the CIA triad further. Or should I just proceed to discuss it again?
I will just read out the questions so that you can read them out in batches so that we can trash them out.
Okay.
Yeah, so the first question is, this is for Caleb. First question is storing/transferring personal data on a cloud platform considered cross-border data transfer? Is storing or transferring personal data on a cloud platform considered cross-border data transfer?
Okay, so I'm going to be very careful in responding to this question because it's arguable, right? And at the same time, but here's my recommendation as to how to approach it. If you would be in that manner, in that case, you will be processing data in a more or less different or new format. And what I'm aware the law will require you to do is to do an impact assessment of the likely things that could happen following your moving that data to that cloud services here in the country. So but whether or not that comes fully under the transfer of data to a foreign jurisdiction is quite dicey, because we need to determine where the cloud services is actually based, or where exactly is the location, or where the servers are based. But I think to that extent, since you'll be processing data, and where data will be processed in a way that subjects it to an automated making decision, or something that is will be kept under a system that is more or less different from what you have done previously, or you're doing previously when it comes to processing the data of data subjects, then of course you would, before you move that data to that cloud services, you need to conduct at least a data impact assessment, and get the the act says in consultation with the commission. So that would be my recommendation. Very hasty to say it comes under that definition because of how technical it is to call other definition of cross-border transfer, except of course the cloud service will be acting on that data from that foreign jurisdiction. But I mean, I'm happy to hear more views on it, but these are my thoughts on that matter. Thank you.
All right, thank you very much for answering that question, Caleb. So I'll move on to Mr. Muritala. Now, Roger Godfrey is asking, what is the striking difference between data minimization principle and the limitation principle?
Okay, they are similar to an extent. So data minimization principle is saying that collect only the minimum amounts of information that you need, right, for you to process a particular data. Don't collect excessive information. And the example I gave initially is that, for instance, if you want to start sending virtual newsletters to people, right, what you will likely need, right, will be their first names and their email addresses, right? Excessive information will include their phone numbers and home addresses because you don't need that information, right, for you to undertake that processing. And the essence of this principle, right, is basically to limit the amount of data that may be compromised in the event of a breach. Now, the storage limitation principle speaks to the fact that there has to be a retention period for the data that you keep, right? Don't keep the data for longer than is necessary for you to achieve the purpose of the collection. Now, the similarity between the two principles is that they are geared towards the same purpose, right? Let us limit the volume of information that may be compromised in the event of a breach.
All right, thank you very much for answering that question, where you highlighted the differences or the striking difference between data minimization and purpose limitation principle. Now to the next question, also for you, Mr. Olatunji. Someone is asking whether data security and data protection are similar or they are synonymous in any way.
Okay, so data protection is the mother term, right? Data protection comprises data security and data privacy. So data protection is like the umbrella term.
All right, thank you very much. Now, Caleb, someone is asking whether there is any clash of jurisdiction between NITDA, that's National Information Technology Development Agency, and this person said NDPA, but I think it's the NDPC, that's the commission in Nigeria's present legal framework. So is there any clash of jurisdiction or power between the NITDA and the NDPC?
Okay, thank you. Yes, really. But thankfully, that's why we have the saving provisions or the transitional provisions um, of the Act, the Nigerian Data Protection Act. I think Section 64 makes provisions for the fact that all other existing rules, regulations that were passed either by NIDA or by the Data Protection Bureau at the time should more or less be interpreted as much as possible in consonance with the provisions of the Act. Like, for example, on the subject of data transfer, like I pointed out, existing the implementation framework, or no, the regulation makes provisions for the fact that the Attorney General of the Federation should work in concert with NIDA to approve data transfers, cross-border data transfers. But you don't find that recognition in under the Act, and the Act merely makes mention of the Commission. So to that extent, where there are inconsistencies with existing legislation, the provisions of the Act will prevail, provided that they align with what the provision. So in that kind of instance, you'll find so the way to approach it really is to approach it from the provisions of the Act, and then, of course, make reference to existing laws to consolidate what the Act says. And then where you find things that clearly have been provided against in the Act, of course, the provisions of the Act will stand out in that instances. So you find those sort of slight differences here and there in the provision, but that's just one of the examples. Thank you.
All right, thank you very much, Caleb, for that insightful answer. Now, Mr. Olatunji, I'm going to give you, say, a number of questions, because there are a plethora of questions here, and I'm going to direct them to you. So the first question is, is it possible to sue a financial institution like a bank, when probably a former employee calls based on your information at the disposal? So she's basically asking if it's possible to sue the data controller, where a former employee of that data controller calls the data subject based on information that they had at their disposal. Then the second question is that what do you say? Someone is asking, what do you say about the NBA national office seekers that call lawyers and send text messages during their campaigns to solicit for votes? If you can just answer those two together.
Okay, thank you, Aramide. For the first question, I think it takes us back to the purpose limitation principle, right? And what I said when I explained that principle is that data must be collected for a specified, legitimate, and explicit purpose, and the data must not be further processed in a manner that is incompatible with the original purpose. So if we take the view that calling an employee after the cessation of his contract of employment would be contrary to the purpose of the original collection, then yes, you have a right of action in that regard. But please, it is important to note that we also need to look at the legal basis for processing, right? If the basis of the processing falls under one of the 6 legal bases, right, the data controller may actually have a defense. So let me just quickly run through those the 6 bases again. The first is consent. So from the question, I can presume that the ex-employer did not get the consent of the ex-employee before the call was made to him, right? So consent is out of it. But is there a contract, right, that licenses the ex-employer, right, to reach you even after the cessation of the employment? You need to consider that. Then is there a legal obligation on the part of the employer to reach out to you for the purpose of the call, right? If there is a legal obligation, then the employer can say that, oh, I have a legal obligation, right, to make this call to you, right? Is this something that relates to vital interest? Vital interest is something that has to do with a life and death situation, right? If I'm calling you regarding something that will preserve the life of somebody, right, then there is a legal basis for it. Then is this something that can be situated within public interest, right? Is there a public interest that will be achieved by that call, right? Then lastly, legitimate interest. Does the employer have a legitimate interest to call you, right? But this should be subject to certain legitimate interest assessments, right? And the rule is that that legitimate interest must not contravene your rights as an individual. So those are the considerations you have to consider before determining whether or not you have a right of action. So the second question was about the NBA sticker and sending messages, right? So I think it ties to the explanation I have given, right? It all boils down to the 6 legal bases, right? I think what NBA would likely say is that, oh, we have a constitution actually, right? What they are doing is it contrary to the constitution of the association, right? That consideration has to be given. If what they are doing is not contrary to the constitution, then the implication is that they are doing what they are doing in compliance with a legal obligation as embedded in the constitution of the association. And they can also make the claim that, see, they have a legitimate interest, right, to reach out to you. So you just have to balance it, to look at all of those conditions, right? If you feel all of those conditions are non-existent, then you can have a right of action in court. So that will be my response.
Okay, thank you very much. Now, Caleb, this number of questions are for you. Now, the first question is, Fatima is asking, since data privacy law is just evolving in Nigeria, are there any key obstacles to ensuring data privacy protection within various businesses or startups in Nigeria? Now, the second question is, someone is also asking, how can one be trained as a data protection specialist, especially as a lawyer? The person is saying that he knows that there might be an online certification or a physical training. Then the third question is, how does the commission, that's the NDPC in this instance, monitor data breaches by data controllers and processors?
Okay, so thank you, Ayomide. in case I miss out any response, just let me know. That, of course, the terrain, the regime for data protection is still upcoming. And for me, when we talk about what are the obstacles to enforcing or data protection in Nigeria, what comes to my mind is just really the level of awareness when it comes to businesses. Most of the businesses that are keeping in terms with data protection are, are, are big organizations that want to keep compliant. They have boards they report to. But I mean, the average businesses a lot of people are doing all kinds of things on that, and they don't even know what they should be doing. Not to talk of the level of awareness. I'm not seeing that level of awareness within the public space, even if there's a legislation that regulates, public institutions, government institutions, or agencies, MDAs that are, interacting with the data of many people. I also think that there's apart from the dearth of knowledge and awareness, there's also a problem. There's a cultural problem with it, right? Not many people don't think what's the big deal in just, giving you information from somewhere or doing that kind of thing. So I really think there's strong need for awareness for people to understand that personal data is a private information, and that by the law you shouldn't collect people's data and transmit it without consent or without a lawful basis for doing so. So I really think those are part of the factors, and that there are too many organizations and not many people are are either licensed as regulators or stakeholders in the space to help people come to terms with what they should do. And of course, Nigeria is still growing on a compliance thing generally to help people be compliant. People like to obey things in default in the country, and they've not done many things. And you would imagine that a lot of people probably wonder what's this data thing after all. I mean, it's just here, and it's not looking as serious as it should be. But thankfully, as you can see, I think recently in August, Fidelity Bank was fined over 500 million by the NDPC, and that was because the way they were processing data was not in compliant with the provisions of the law. So that's, for me, part of the obstacles. And we need more people to go into this space. We need more professionals to go into the space and then take up certifications that allows them to either advise as a DPO or join a DPCO. All right. Okay, so that's that for me. I think the third question, if I remember correctly, was how the commission is able to manage breaches. There are many ways the commission is able to monitor breaches by requiring that if you process a minimum of 200 personal data, you should be registered. And because you are registered, you are required to file and submit audit data compliance audit reports to the commission, and you're not allowed to do it yourself. There are licensed data protection organizations that have the responsibility to do that on your behalf. And so there's a yearly requirement to file data audit returns. And in those returns, the commission has the opportunity to see how well you are keeping in terms with compliance. And so you can imagine that a lot of people who process that much data in 6 months, 200, you should have a wide bracket of people who are doing that. And if they have a DPO or they are filing their audit returns, the commission is able to watch what they are doing. And if there's a data breach, the requirement of the law is that you have to file or notify the commission within 72 hours. And if it creates a high risk that the rights of the data subjects will be infringed on, you ought to even inform the data subject themselves themselves. So those requirements of the law allows the commission to keep a check on what they're doing. Apart from that, the commission has the powers to investigate either suo motu, that is by themselves, or pursuant to a report or a complaint by anybody. So if you work in an organization and your data, your personal data was mishandled or shared or was used in an unauthorized form, you petition, you write a petition to the commission, whether or not those people are a data controller of major importance or not. And the commission will immediately investigate it and has the power to impose sanctions and to command or order them to do what they're supposed to do. It even may grant damages to the data subject, the aggrieved data subject. So those are part of the ways the commission is able to keep a check. If everything works well, those are the avenues the commission is able to oversee the activities of people when it comes to data compliance. It's just that the policing is not on the top-notch level. And I'm sure as time goes on, for late filings of audit reports and all of those things, they are sanctionable under the Act. We will expect to see that people will begin to follow due process. I think there was one more question. I'm trying to see if I missed that. Okay, I don't know if I've answered all the question or I missed one.
Yes, you've answered the question. Thank you very much, Mr. Lagio, for your answers. So, Mr. Muritala, I have a number of questions for you. Now, the first question is from Onye Noli, and she's asking that she would like to get your thoughts on the extent of the obligation of an employer to provide reference in respect of an ex-employee without violating the ex-employee's data privacy rights. For instance, where an employer discloses to the new employer, I think she means the employer, where an employer discloses to the new employer that the ex-employee was terminated due to his ill health, which affected his performance at work. Will that disclosure amount to a breach of the ex-employee's sensitive personal data? So that's the first question. Second question is, are there any legally prescribed periods for employers to hold on to the personal data of the employee after termination of the employment relationship? And thirdly, the third question is, for social media platforms like WhatsApp and others which do not have a physical office in Nigeria, how do they enforce compliance and solve the privacy policies challenges?
Okay, thank you, Ayomide. So for the first question that relates to work reference, so it speaks to an intersection between labor law, right, and the law of data protection, right? So I'll first start by mentioning that by Section 63 of the Data Protection Act, right, where there is a conflict between other laws and the Data Protection Act, as far as processing is concerned, right, the Data Protection Act will prevail. So to that extent, where an employer is giving work reference, it is imperative for the employer to ensure that for them to release any information, right, relating to the employee, there has to be a legal basis for releasing that information. It still goes back to the legal basis. For instance, even the contract of your employment that you executed with your employer, there is a post-employment obligation in that contract for your employer to give that work reference, right? It means that there is already a contract that binds you, which licenses the employer to give that information, right? So it's about that intersection. So you need to go back to the legal basis and determine whether or not the employer has complied with those conditions. That's number one. Then number two, for the period of retention for employees' data, I'm not aware of any law that talks about a definite period of retention, but like I said, it still goes back to the storage limitation principle, right? Keep data only for the period you're required to process the data. Once the intended purpose of the data has been fulfilled, you go ahead and discard the data, except there is a regulatory or legislative requirement somewhere that requires you to keep the data for a specified duration, right? But like I also mentioned earlier, as a data controller, you need to establish retention schedules, specifying the retention periods for the data that you keep. If you don't have those retention schedules, you're already violating the Data Protection Act, right? So employees need to know what the retention schedules are, right? Or if I leave my employment, this is the period for which the employer can actually retain my data. Except you can now link it maybe to some other obligations. For instance, I mentioned Section 38 of the Cybercrimes Act earlier, the one that talks about service providers retaining subscribers' information for up to 2 years. So except you can link it to those provisions, in the absence of that, you need to stick to the retention schedule, specifying the retention period that employer is maintaining. So please remind me of the last question.
Okay, so the last question is for social media platforms like WhatsApp and others. We do not have a physical office in Nigeria. How does the NDPC enforce compliance and solve the privacy policy challenges?
Oh no, that's easy, right? So if you have a presence in Nigeria, so the scope of the Data Protection Act are three, right? As provided in Section 2 of the Data Protection Act. So the first one is data controllers that are domiciled, residents in or operating in Nigeria. That's one. Or where the processing of the personal data is in respect of data subjects in Nigeria, right? Even if the data controller or data processor is not operating in, domiciled in, or resident in Nigeria, right? And they are processing the personal data of data subjects in Nigeria, they are caught under the provision. So the implication is that if they violate any such provision, they have their head office, right? You can always sanction them. For instance, I recall that some time ago, Meta was fined in Ireland, right? And I don't think their head office is in Ireland. They were fined about $200 million, right, for violations relating to transparency issues. So insofar as they have a presence in Nigeria, and by presence, they are processing personal data of data subjects in Nigeria, they are subject to our laws and they can be fined and sanctioned in line with the law. Thank you.
Thank you very much. Now I'll move to Caleb. So somebody is asking that about the legal compliance with he's asking about when you spoke about the guidance notes on the different thresholds for high-level data. He's asking for some clarification because he didn't seem to get you. So you need to go over that again. And then another person is asking that if you can kindly explain the term data subject, because we've been repeating it from time to time without really explaining what a data subject is. And then another person is asking, what's the difference between a data protection officer and a licensed DPCO?
Okay, so I'll rely on you to make sure I don't miss any of those questions you asked. So a data subject simply means a person to whom the data relates, right? I think that's the definition even in the Nigerian Data Protection Act. Is an individual. It excludes corporates, right? Corporates are not data subjects, right? Corporates, that's the reason why corporates will usually, if they have data they don't need to be shared without authorization, they put in policies and they put in NDAs and non-disclosure, confidentiality clauses in their agreements and all of those things to protect their own data. But corporates are not envisaged when it comes to data subjects. Data subjects simplicitize people, me and you, the person whose data is the subject matter of processing, All right. And the second thing is on the issue of specialization, especially for legal practitioners. There are a lot of promising opportunities now in this space, and that's because you can apply, you can become a data protection officer of an organization, and the requirement, even stated in the law, is that you should be able to, you should have basic knowledge of data protection laws and practices, and you should be able to carry out the tasks described under the Act in helping your client with their data protection. So it's really about just getting certifications. I think even the commission is trying to put up something that more or less certification that allows data protection officers to be licensed by them as haven't been trained by them. So I think that's the first step to take, because the requirement for data protection compliance organizations, who are the ones who are licensed by the commission to carry out regulatory, to carry out compliance checks for the data controllers and data processors. The requirement is that at least they must have amongst them persons who are well trained or who could act as DPOs, who are exposed to data protection laws and practices. So in that, I'm also going to distinguish again, just for clarity, the difference between the DCPO and then the DPCO and then the DPO. The DPCO, the Data Protection Organization, is usually licensed by the commission, and their work essentially is more or less to act as an arm of, or to act in the interest of the commission in checking what data controllers and data processors are doing and how compliant they are. So where they are licensed, then they can now help they now register. So DCPOs are the ones that register data controllers and data processors on with the commission. And then after that, the data controllers and the data processors, those are the companies that process those data, can now engage their own services that engage the data protection and the data compliance organizations to be in charge of their audits, be in charge of helping them with their data impact assessment. This is different from the data protection officers that are more or less working in-house, and that in-house arrangement could either be employment or service that assists them in ensuring that they are compliant with the provisions of the law, and that they keep all the requirements, their policies are right, and just assist them in the day-to-day workings of to ensure that they are processing there and giving them all the advisory that is required. Now, let me mention that there's also the Code of Conduct for Data Protection Compliance Organizations, right? 2023. If you can get your hands on it, it just contains what is expected of data protection compliance organizations, and those who fall under the category, the code of their conduct, what is expected of them, and how they are required to work with the DPOs who are that are resident in the organization to ensure that everything they are doing is in good order. So the work of the compliance data compliance organization includes registration of the data controller, development of compliance schedules, very key, compliant audit and filing of the returns on their behalf, the commission. So think of the compliant I mean, with subject to some differences, the same way only the accredited agent has the access if you need to apply for that, you need to those are part of the considerations you need to have in place. Preparing of the data impact assessment, those are parts of the many duties that of the data compliance organization. I was comparing them with an accredited agent of the CSC. So a DPCO, that's the compliance organization, will first be registered as such or licensed to do that work with the commission before they can now do those services for the data processor and data controllers. And that leads me to, I think, the next question. I've talked about specializing. It's really about you having getting those certifications and then either applying to work with either a data compliance organization or a data officer. And the good thing of this, just in case we have non-lawyers on the call, you don't have to be a lawyer to be a data protection officer. You just have to have all the knowledge and processes that are involved with that. I think that's, I don't know, am I leaving any other question?
Yes, so a lot of people have in the Q&A, they've said that you did not expatiate on the certification process. I think they want you to be more specific. I'm aware that the NDPC has actually partnered with the Institute of Information Management on certification, and I'm also aware that there is a privacy academy whereby they actually certify young professionals on data protection. So you can just go online and research, go on LinkedIn, go to NDPC's website. All that information is there. Their Instagram, their LinkedIn. They're actually very active on social media, and do your research so you can find out more about the certification. So thank you very much, Caleb, for answering that question. So to Mr. Olatunji, now someone is asking, can an agency, so first question is, can an agency that wants to refer models or ushers to companies through its form state that they will keep the ushers' pictures and personal details continuously despite the formal termination of the professional relationship and not be held liable to litigation because the usher signed the form and gave their consent? Is this a data breach? And the second question is, what is the liability of an organization, in bracket, data controller and processor, for unauthorized and illegal processing?
Please, can you take that again? Sorry.
The first or second question?
No, everything. Sorry. Apologies.
Okay, so the first question is, can an agency that wants to refer models or ushers to companies through its form state that they will keep the ushers' pictures and personal details continuously despite the formal termination of the professional relationship and not be held liable to litigation because the ushers signed the form and gave their consent? Is this a data breach? So that's the first question. Now, the second question is, what is the liability of an organization for unauthorized and illegal processing of the personal data of data subjects by its employees, despite having put adequate data protection measures in place? I'll repeat that. What is the liability of an organization for the unauthorized and illegal processing of the personal data of data subjects, by its employees, despite having put in adequate data protection measures in place. Now, the next question is, Finfolua is asking that if she mistakenly sends an email and expose other people's emails address to others in that context, has she breached the right to data privacy? Is that a breach? Is this something that her company can be held liable for going forward? Then the last question for you in this series is, does the act, I think in this case is the NDPA, does the act frown at non-compliant registration of data subjects in an organization system? My example is with respect to a bank sending me an SMS that an account has been created for me, which I'm well aware I never approached or wrote my details somewhere to this bank. So, thank you.
Okay, thank you, Aramide. So the first question about an agency continuously keeping pictures of their models, right? So I presume that at the point when the contract was being entered into, the models must have given their consent, right, for the agency to continue to retain the data, right? So as such, there is already a legal basis for that processing, but consent is not absolute, right? I think Section 35 of the Data Protection Act says that as a data subject, you have the right to withdraw your consent, right? So if the consent is withdrawn, the implication is that there won't be a legal basis for continuing to keep that data. So that's number one. Then number two, regarding liability generally. So what the data protection, so there are enforcement orders and compliance orders, right? So when we're in breach of the Data Protection Act, the compliance order could take the form of an order from the NDPC, right, mandating you to comply with the obligation that you have breached. It could also take the form of a warning, right? So, but the very stringent ones are the enforcement orders, right? So the enforcement orders could take the form of NDPC mandating you to pay compensation, right, to the data subject. It could also involve the payment of penalties. So the regime is that there are two classes of penalties depending on whether or not you're a data controller of major importance or not. So if you're a data controller of major importance, you can be subject to a higher maximum amount, which could be the greater of 10 million naira or 2% of your annual gross revenue in your preceding year. In fact, I think that was the basis upon which the NDPC fined Fidelity Bank over 500 million naira. Then the other one that is for data controllers who are not of major importance, right? So there is the ordinary minimum amount, which is the greater of 2 million or 2% of their annual gross revenue in the preceding year. So yes, so that's that. Then the one about mistake, right? The implication is that there has been a breach, right? And if there is a breach, there are consequences. But drawing from our knowledge of the law of contract and principles around mistakes generally, I know mistakes of fact are excusable as long as it is not a mistake of law. So if that genuine defense, right, can be put up to show that this thing happened as a result of a mistake, you may be exposed, you may be excused, but at the end of the day, it's a question of fact, whether or not it was a mistake or maybe you did it with malice. So it depends on how you're able to explain the situation. So the last question, sorry, Ayomide, please, can you take that again?
Okay, so the last question is, what is the liability of an organization, data controller or processor, for unauthorized and illegal processing of personal data of data subjects by its employees, despite having put adequate data protection measures in place?
Okay, that speaks to the answer I had already given in relation to liability, right? So your liability can be in form of a penalty, payments of compensation, and even beyond that, right? The law gives, because when I was talking about the accountability principle, I mentioned the fact that as a data controller, you owe a duty of care, right, to your data subjects. right? So to that extent, the data subjects can even maintain an action either in torts or in contracts, right? In furtherance of the duty of care that you owe the data subject. Then beyond that, if you look at section 1 of the Act, the essence of the Act is to safeguard the fundamental rights, right, of citizens. And to that extent, the data subjects can decide to bring a fundamental right enforcement action, right, against you, either at the state high court or the federal high court, as the case may be. So those are some of the consequences beyond the penalties or compensation that may be imposed by the commission. Thank you.
Okay, thank you very much, Mr. Muritala, for answering all our questions. And just to say someone's statement, so Stella is saying that she's thanking us. She's saying that NBA ICL should invite our speakers to enlighten lawyers on data protection, and she says that she has been so blessed with the lecture so far. Thank you. So just to round up, so that brings us to the end of this enlightening and insightful session, whereby we had an expert speak on data security and legal compliance and gave us practical insight on how to safeguard your business